I'm a philosophy professor, so my job is to make your head hurt by thinking hard for the last half hour. In fact, my remarks are very much in keeping with what we've just been hearing from Peter. I'm going to focus, though, really on an opportunity we have to change the law in this country. That doesn't come around all that often. The Law Commission's consultation is out right now. Comments due by the 2nd of November. Also in Northern Ireland, there's a bill before the Assembly that's a version of the Mental Capacity Act. So the question really I want us to think together about is, if we could change the Act, and we might be able to, what should we be doing? And I want to think about that as a philosopher, but also from an international human rights perspective. So my title is Respect for Will and Preferences in Best Interest Decision Making. So very much in keeping with this recent case. Let me start with a dilemma that may be familiar to some of you, at least in its form. So Brian is an adult living with the consequences of a serious brain injury sustained in a boating accident. He often fails to recognize the extent of the deficits associated with his injury, which include episodes of disorientation. And he expresses a strong wish to buy a kayak and go solo kayaking on the Firth of Forth. I don't know if you've been out on the Firth of Forth. It's sometimes a very tumultuous place. So look, what do we do in a situation like that? Well, look, the first question with the MCA would be, does he have capacity? And if he does, go kayaking. It's up to him. We can, try to persuade him and we can lobby him and so on, but it's his decision. But now what about the situation where he lacks capacity? What do we do then? We've got a very risky decision and a very strong preference to engage in it. What happens next? And of course, you can take that same schema and see it in many, many different scenarios. A discharge situation from hospital, the kind of case we've just been hearing about with an amputation, and so on and so on. I want to think about it in the context of the CRPD. Can I just ask how many people here, before they arrived today, knew about the Convention on the Rights of Persons with Disabilities? It's still a pretty small percentage of a very informed community. So I'm going to just spend one slide teaching you some basics about that because it's important. So what are we talking about here? The CRPD is a major international human rights instrument. It's a UN convention adopted by the General Assembly in 2006. It's the most recent human rights convention. It was ratified by the UK in 2009 and then independently by the European Union in 2010. So we're doubly bound by it. It's actually the only international human rights convention to which the EU is an independent signatory. It establishes a set of human rights standards governing the treatment of persons with disability, and that includes persons with cognitive and intellectual disabilities. And it's administered by what's called a treaty body, the Committee on the Rights of Persons with Disability, which sits in Geneva twice a year. So one thing you need to know is that there's an upcoming review of UK compliance with this convention. So it doesn't have the force of law in your practice, but the UK government has committed to adjusting its laws and practice to comply with these standards. And there's a process whereby this committee is going through all the signatory nations to review compliance. They, in fact, recently conducted their review of the EU's compliance on the 28th of August this year. We went along to that. It was a historic occasion, the first time that the UN has reviewed a regional body from a human rights perspective. And the review of UK compliance is coming up. It had been scheduled for this year. It's delayed for reasons we can go into if people are interested. We're led to believe it will now take place in 2017. In fact, it's already underway, at least in part. The first stage of it was that upon ratifying the convention, the UK had to report to the treaty body about how we're doing. How well are we respecting the rights of persons with disability in the UK? And they filed their initial report with the UN back in 2011. And I think there's a broad consensus now in the human rights community that it's a very poor report. I think there was very low understanding at the time of what the convention required, and there was a kind of degree of confidence that everything is compliant here. In our group, we call it the compliance complacence report. And I've yet to find a civil servant who will admit to having written it. So last year, my research group at the University of Essex did a piece of work for the Ministry of Justice where we gathered together a group of experts to pose the question, how is the MCA doing from the perspective of this CRPD compliance? And you can find that report on our website, the Essex Autonomy Project, but I'll save you 50 pages of reading. Our conclusion was the MCA is remediably non-compliant. So we disagree with that 2011 initial report that said everything's fine here, but we also disagreed with some activists who say that the MCA is badly flawed and needs to be really scrapped. We think it's non-compliant, but that it can be fixed. And so the question really is how to fix it. I'll come back to the details of that in a moment, or at least to some of the details. But one thing, of course, now we live in a devolved world here in the UK. So the question is not just about the Mental Capacity Act, which applies only in England and Wales. It's also about the Adults with Incapacity Act in Scotland, which is a similar but nonetheless different piece of legislation. And Northern Ireland has never had a statute in this area, but they've got one right now being considered by the Assembly, which may collapse at any moment. We don't know if it'll actually come into law, but there's an ad hoc committee that is considering it there. So our group now is taking what we call a 3 jurisdictions approach, and we have funding from the research councils to provide technical research support to government bodies ahead of this UN review. So there's an opportunity to reflect on what needs to be changed, what could be made better. I'm just going to report now in my time today on one slice of this challenge. And I'm going to focus in on one piece of this convention. It's a very complex document, but the piece that really matters for today is Article 12, Section 4. So this is my one busy slide, but let's just read it together. This is about equal recognition before the law. And what does it say? Section 4. States parties shall ensure that all measures that relate to the exercise of legal capacity provide for appropriate and effective safeguards to prevent abuse in accordance with international human rights law. So it's about safeguarding. How do you safeguard people's rights? And then there's a list of what those safeguards need to include. Such safeguards shall ensure that measures relating to the exercise of legal capacity respect the rights, will, and preferences of the person, are free of conflict of interest and undue influence, are proportional and tailored to the person's circumstances, apply for the shortest time possible, and are subject to regular review. All right, so the question is, how's the Mental Capacity Act doing against that standard? Those are the safeguards that we have committed to putting in place. Do we have them or not? And let's focus specifically on the Mental Capacity Act. All right, so the relevant piece here, and I'm going to focus on that bit in red. There's a lot of interesting detail in there, but let's just focus on the bit in red. Safeguards to ensure respect for the rights, will, and preferences of disabled persons. All right, well look, the Mental Capacity Act passed in 2005. Remember, the CRPD came into effect was adopted in 2006, so it went through the legislative process without the benefit of the CRPD. It doesn't talk about will and preferences, but it does, as we've just been hearing, talk about wishes and feelings, beliefs, and values. So the relevant place here is Section 4.6. He, the person making the determination of best interests, must consider, so far as is reasonably ascertainable, the person's past and present wishes and feelings, beliefs and values, and so on. Now, we've just been hearing about Judge Jackson's principle, there's no upper limit to what the role of those would be. The question really here is there a floor? Is there a minimal basis that really needs to be in place? Now, I'm a philosopher, so I like proofs. So here's my proof that we're not compliant with the CRPD. What does that MCA requirement hold? It's all about the verbs here. It says we've got to consider the wishes and feelings, beliefs and values of P. What does the CRPD require? Respect for will and preference. So consideration is a lower standard than respect. I could consider your will and preferences all as part of my strategy for minimizing my liability and trying to figure out what the costs are going to be associated with violating them, right? That wouldn't be enough. That wouldn't be respect. So consideration is a lower standard than respect. CRPD requires respect, so we're not compliant. The MCA fails to satisfy the CRPD requirement for safeguards that ensure respect for the rights, will, and preferences of disabled persons in proceedings pertaining to legal capacity. So all is not well. This is what I mean by remediably non-compliant. This is not an irreparable problem. We just need to ratchet up the safeguards a bit, right? We need stronger safeguards around will and preference. So the question then, and this is what I want to spend the last bit of my time on today, what's the fix? How should we fix this problem? What's the appropriate remedy? And I'm not going to tell you the answer to that. You're going to tell me the answer to that. And then we'll tell the Law Commission, and they'll tell Parliament, and we'll change the world, right? And we'll also tell the ad hoc committee in Belfast. There's a real opportunity right now, in fact, this week before the 2nd of November, to make an impact on this question. So the three possibilities that are currently on the table, one of them is the Geneva proposal, one of them is the Westminster proposal, and one of them is the Belfast proposal. So let me quickly run through those three, and then we can, if we have time, I hope, have a discussion about which, if any of these, we think is the right one. So the Geneva proposal is what I call the principle of deference. What does that mean? Okay, the principle of deference, sorry, this is now talking like a lawyer, but we have lawyers in the room. When a person A makes a decision on behalf of another person B, who lacks decision-making capacity in a matter, A shall act on the basis of B's own will and preferences in the matter, provided that these are consistent with the criminal law that applies to all on an equal basis. You can't do anything you want, right? You have to obey the criminal law, but the principle of deference would say, within those limits, we would go with your preference in the matter, what it is that you want to do, even if you lack capacity. Of course, we might not know what your will and preference is, so the principle of deference has a second clause where A is unable to determine B's will and preferences in the matter. A shall act on the basis of the best interpretation of B's will and preferences in that matter. So you do your best to figure it out. What is it that they want? And you act on that. So the principle of deference is very popular in Geneva. And the relevant document here is called General Comment Number 1 from this committee, a very controversial document, but here are just two sentences from it. A supported decision-making regime, that's what they like, comprises various support options which give primacy to a person's will and preferences and respect human rights norms. And where, after significant efforts have been made, it's not practicable to determine the will and preferences of an individual, the best interpretation of will and preferences must replace the best interests determinations. They say we've got to abolish the best interest standard, and we go instead with supported decision-making, implement the will and preference. So we think that the principle of deference is not viable. And here I have to say I've made some enemies in Geneva, I'm sorry to say. I wish we were all fighting on the same side, but here I think that the committee is wrong. And there are three levels of objection here. We're short on time, so I won't go through them in a lot of detail. But first of all, they're ethical objections. I should say, look, there are going to be disagreements about ethics in this domain, and so the ethical objections, I think, can't be decisive, but I think we have to think about them. We'd be remiss if we just passed them over. The problem here is that if we really just went with the principle of deference, it would require A to abdicate his duty to protect B from B's own destructive will and preference. So in my family, a member of my extended family suffers from diabetes. He manages it himself most of the time, but occasionally it slips out of control. There was a very memorable day in my family at the end of a long day on a canal barge trip where he really lost it. His blood sugar really dropped. He entered an acute confusional state, and he was right around one of these locks with a heavy steel boat, and he was very belligerent and willful. He did not want any help. And we tackled him. I mean, we basically deprived him of his liberty and got him to a place of safety. We did not just defer to his preference to be left alone in that situation. And here I just speak from an ethical point of view. I think we did the right thing, and we would have done the wrong thing if we had just left him alone because he wanted to be left alone. So I think there's circumstances where ethics requires a certain amount of intervention. But then there are philosophical objections. Remember that that clause in the CRPD says, respect the will and the preferences. And preferences is plural. What about situations where will conflicts with preference? Or I have preferences that can't themselves all be satisfied. Sometimes B's will conflicts with B's preferences, or B's preferences conflict with each other. So it's just impossible for A to defer to both. You need some additional principle. So the principle of deference is philosophically inadequate. And then finally, I think it's also legally problematic because sometimes circumstances arise where A can respect B's rights only by overriding B's known will and preference. The right to life is involved here as well. So I think that the deference principle, the Geneva position, is really not the right one here, and I think that we should not advise Parliament or the Law Commission or the Belfast Assembly to adopt it. So where does that leave us? I think we're really in a position of looking for a principled middle ground here. We've seen that the current MCA requirement to consider the wishes and feelings is really too weak to satisfy international human rights standards. But we've seen that the committee's position, we should always act in accordance with will and preference, that's too strong. So we're really in a position of trying to plot out a middle ground. Those are kind of the boundary conditions, and then we've got to figure out something that's a principled way of going in between. I'll just conclude by outlining two possibilities for occupying that middle ground. So one of them, many of you will be familiar now, we just had a very helpful session with Graham on the Law Commission's report. One of their proposals is exactly about this. Provisional Proposal 12.2. Section 4 of the Mental Capacity Act, that's the best interest section, should be amended to establish that decision makers should begin with the assumption that the person's past and present wishes and feelings should be determinative of the best interests decision. Okay? So that's stronger than merely consider, but weaker than always defer. So we think of that as something like a rebuttable presumption approach. You begin with the presumption that it's going to be determinative as the kind of starting point here. It's to establish a hierarchy in the checklist of Section 4. Now, right now, my next job on the train home is to write our response to the Law Commission, and here's what I'm going to say. We think that the Law Commission's provisional proposal marks a step in the right direction, but it cannot by itself solve the problem. And so I just want to try to explain here why I think it's not by itself adequate. And to do that, I'm going to give you a fancy philosophical analysis, what I call the roundabout theory of decision making. Okay? In the history of art, there are all these paintings of man at the crossroads. You know, you come to the crossroads and you've got to make a decision. But here in England, we have roundabouts. Those are decision making moments. And so I just want to give you the roundabout theory of decision making. Okay, so think about coming up to a roundabout. You got to make a decision. There are all kinds of different ways to go. The pub is over there. The football match is over there. My mother-in-law is up here, right? Which way am I going to go? Well, what's the guidance there? What kind of sign are we going to put there? Well, right now, you have capacity. The sign at the crossroads says, use your decision-making capacity, right? What do we mean by decision-making capacity? It's a function that takes as its inputs a variety of sometimes conflicting desires and wishes, and it produces as its output an intention, right? There are lots of different things I might want to do today. I use my decision-making capacity. I'm going that way, okay? So that's the sign at the roundabout, at the crossroads. But all right, what if I don't have decision-making capacity? How do I navigate roundabouts without decision-making capacity? Well, the short answer is I need somebody else in the car with me, right? I might be an advocate. The MCA calls it the best interest decision maker. All right, so now we have a new situation. There are two of us now together, and you are the best interest decision maker, right? I'm over there not in the driver's seat, and somebody else is making that decision. So what do we put as the guidance sign at the roundabout? Well, if we follow the Law Commission, it'll be this sign. Start from the assumption that the wishes and feelings of P shall be determinative. Can you see the problem with that? It tells me where to start, but it doesn't tell me what to do after I start, right? It's essentially incomplete. Okay, it tells me the starting point for this kind of very high-stakes decision, but I need more than that. I'm going to start from that. I need to know, then do I defer to it? That would be one thing. What's the next bit? So we think that the Law Commission's report is helpful, but not by itself sufficient. So I come now to the third option that I know about that's on the table. Others may know about others. That's the principle of special regard. So this is what's now come up in the context in Northern Ireland. Northern Ireland really started out by largely copying the approach of the MCA, but then through the democratic process there and some of the lessons that have emerged from England and Wales, some interesting changes have been introduced. So this is my last set of slides here. So here's the initial draft text that was circulated for comment in Northern Ireland. It's almost exactly like the MCA. It says that person, the person making the determination of best interests, must take into account past and present wishes and feelings, all the same stuff that's in the MCA. I think that's basically a synonym. Consider, take into account. There's a difference in words there, but no real difference in principle. That went out for comment, and when the bill was finally introduced in the Assembly, take into account had disappeared, and in its place, have special regard to. Have special regard to. I have to say, when we first visited the ad hoc committee there, we were a little skeptical about this. What does have special regard mean? You like put on your 3D glasses and a certain kind of angle of vision. What does that actually mean? We wanted to know what exactly is special regard. It's not defined in the bill, but we can get an idea by looking to other statutes. I won't go through all of this in detail. There are 25 statutes in the UK that use this expression, special regard. The one I think that is most useful for these purposes is the Planning Act about listed buildings. The Planning Act about listed buildings says if you're an inspector and a planning application comes to you and it impacts upon a listed building, you should have special regard for the impact of that on that listed building. Special regard. It doesn't define special regard, but then there's a guidance document, the Planning Policy Statement 5, that unpacks that concept. And what does it say? There should be a presumption in favor of the conservation of designated heritage assets, and the more significant the designated heritage asset, the greater the presumption in favor of its conservation should be. Substantial harm to or loss of a grade 2 listed building, park, or garden should be exceptional. Substantial harm to or loss of designated heritage assets of the highest significance should be wholly exceptional. So can you see that's getting a little bit more than just a starting point there. It's saying, yes, start with that assumption. You're not going to do something that affects a listed building, but then it's talking a little bit, it's filling out in fairly vague terms, but it's giving you some instructions. Hey, really exceptional that you're going to override P's will and preference. Wholly exceptional if it's a really significant interference with those. And there's one other clause in that guidance I think is important. The greater the harm to the significance of the heritage asset, the greater the justification will be needed for any loss. So it's like the stakes go up. The more damage you're doing to that person's will and preference, the more interference, you're going to have a more compelling reason. So I stop at that. I have a slide of conclusions. Here they are. The MCA's best interest provisions do not currently comply with the CRPD safeguarding requirements regarding respect for the rights, will, and preferences of persons with disability. That's the bad news. The remedy is not to be found by adopting a principle of unqualified deference to the will and preferences of persons lacking in decision-making capacity. The Geneva position is wrong. The solution is to be found in the middle ground between a principle of considering the will and preferences of such persons and a principle of unqualified deference thereto. And finally, both the rebuttable presumption approach and the special regard approach provide a principled strategy that, with suitable development, can be adopted in occupying that middle ground. Thank you.